Are a corporation's directors required to treat all shareholders equally? The Delaware Supreme Court considered that question in Nixon versus Blackwell. E.C. Barton founded E.C. Barton and Company and held substantially all its stock, which was divided into two classes, Class A voting stock and Class B non-voting stock. Upon Barton's death, 49% of the Class A stock was bequeathed to 8 long-term employees. The remaining Class A stock and 14% of the Class B stock was placed in a 15-year trust for those 8 employees. Shares of the remaining Class B stock were bequeathed to Barton's widow, Martha, and other family members. By 1975, Martha's 2 adult sons, Guy and Owen Blackwell, became the primary non-employee Class B shareholders, having rejected a series of the corporation's self-tender offers, in which the offer price increased each time. There was no public market for either class of the corporation's shares. The Blackwells thus owned significant equity in the corporation, but had no voting rights. In 1975, the corporation established an Employee Stock Ownership Plan, or ESOP, a profit-sharing plan. Terminating or retiring employees could receive their ESOP interest in cash or in Class B stock. The corporation also purchased life insurance policies on the key employees who owned Class A stock. As those employees retired or died, the corporation could substitute Class B stock for their Class A stock, so that the voting Class A shares could be reissued to new key personnel. In return, the board intended to use the life insurance proceeds to repurchase Class B stock from executives' estates. The Blackwells sued the corporation and its directors, alleging that the defendants paid small dividends to force the Blackwells to sell their shares at a discount. Further, the Blackwells claimed that the corporation discriminated against them by providing employee Class B shareholders with an option to exchange shares for cash that wasn't available to the Blackwells. The vice chancellor held that dividend decisions came within the business judgment rule, but held that the ESOP and insurance policies were inherently unfair to non-employee Class B shareholders such as the Blackwells. The corporation appealed to the Delaware Supreme Court.